And thank you all for joining us. We're excited to be here today for the second of a two-part series about art and estate planning. A few weeks ago, we discussed lifetime planning with art. And in case you missed it, that presentation was recorded and is available. We'd be happy to send instructions for how to access the recording. Please just send one of us an email. Our information will be listed at the end of the presentation. In this session, we'll focus on testamentary transfers of art. Specifically, we plan to discuss post-death sales of art, considerations when dividing arts among beneficiaries, issues to consider when gifting art to charity, and administrations of estates with art. I'm Amanda Cruz. With me is my colleague, Benjamin Bonestrew. And Ben is going to kick us off this morning by talking about post-death sales of art.
Thank you for that introduction, Amanda, and thanks to everyone out there for tuning in this morning. So you have a client with a wonderful collection of Picassos, but unlike those Picassos, your client is not going to live forever. So what should that collector and that collector's fiduciaries be thinking about to ensure that those pieces live on in a way that the collector intends or desires after death? And that's what we're here to talk about today. There are a number of different things that a collector can do with their art at death. One of the most straightforward approaches is to simply have their estate sell the art, collect the proceeds, and distribute that to the beneficiaries. But even this approach has some nuances that are different than dealing with typical assets in the estate. For example, unlike a brokerage account, art is a tangible, fragile asset that needs to be properly stored and maintained. It's very important to have a safe, secure location to put the art after the collector passes away. It will also need to be insured, very important to get the proper insurance in place. Once sold, there's going to be additional fees as well, such as commissions from galleries or auction houses, as well as shipping costs to actually get the art to the new buyer. And additionally, it could take time to sell the art, unlike marketable securities, that it can take a while to actually sell a piece of art from the estate. It might be difficult to find a buyer, or the fiduciaries might determine that the best price they're going to be able to get is at an auction being put together a year from the collector's death. That's something to take into consideration, especially since you're going to need to ensure and have proper storage of that art for that period of time. One thing collectors and fiduciaries might want to think about to mitigate that long hold time before being able to sell the piece is developing relationships with auction houses and galleries and dealers to get a sense of where the pieces might fit for potential sales, or the best galleries or auctions that might be coming up, or even developing a list of potentially interested buyers to help speed up the sale post-death. For tax considerations, these are pretty straightforward. Like we covered last time, if the art is sold during life, there's going to be the capital gains tax at 28%. If the artwork was owned by the collector at death, though, and included in the collector's gross estate, it would be subject to an estate tax, and if the collector's total estate does exceed the federal exemption amount at the time, there would be a 40% tax on that. And if they are residing in a state that has a state estate tax or inheritance tax, those would be considered as well. But it is important to remember, if it is includable in the collector's estate, there will be a step up in basis that would wipe out any capital gains if sold by the estate. Another issue that needs to be taken into account is the valuation of the art. And not just for tax reporting for estate taxes, but also to make sure that you're not selling below market value. Again, running brokerage accounts through a valuation software can be very easy, but assigning a value to a medieval tapestry, that can be quite difficult and requires a specialist to do right. Unlike income taxes, estate and gift tax rules do not require qualified appraisals by qualified appraisers. However, again, to properly determine the art value, you are going to want you're going to want somebody who's a specialist in the area, reputable and familiar with that medium and the appraisal process. There are places out there, there's specialists out there who do that. You can also use services from auction houses like Christie's, Sotheby's, or Hinman, and if they don't have the right professionals or specialists in that medium, they can certainly direct you to folks who can help. And I would also say that having good relationships with professionals who can perform these types of appraisals would be a great value add for family offices and trust companies, not just for post-death issues, but also to help clients keep a regularly updated inventory of their art and its value. That certainly helps in the planning process. Another reason that you need to have a good appraisal in place is if your estate tax return happens to get audited. If you do have a return that gets audited and you have a piece of art there with a claimed value of $1,000, there's a good chance your valuation will be reviewed by the IRS Art Advisory Panel. This panel is made up of 25 individuals. They are all experts in fields related to art, such as museum directors, curators, scholars, art dealers, auction reps, and appraisers. This panel meets once or twice a year for 1 day, and they review hundreds of works per session. After reviewing the art and the supporting information, the panel makes a determination upon whether or not the claimed value is acceptable. If they feel it is not, they will make an alternate recommendation. Although technically that recommendation isn't binding, it is generally what the service determines to be the value for their purposes. You can see on the screen the type of information that is requested on the art advisory information request. Ideally, you'll have already gathered all this information and submitted it in your professionally done appraisal, which would avoid needing to have to gather this information at the time of audit and hopefully have the panel even question the value that you find. So Amanda, I will pass it back to you.
Thanks, Ben. I'd like to pivot a little bit to discuss things to consider when you or your clients are devising art in your planning documents. In general, there are two ways you can distribute art at your death. You can either gift the art to your beneficiaries or donate it to a charitable organization. The tax laws governing these types of distributions differ from laws governing distributions of other types of estate assets. And ignoring these laws can result in unnecessarily high capital gains tax for your beneficiaries, in addition to potential income or estate tax penalties. But equally troubling are the issues that might arise from disagreements among beneficiaries. Art can be really hard to fairly distribute among beneficiaries. Each piece is just that, right? It's one piece. It can't be split or easily given to multiple beneficiaries. I've seen disagreements between beneficiaries resolved with complicated schedules, something like a custody agreement for a piece of art so that beneficiaries could share a single piece of art, but generally that's not the ideal scenario. Something like that typically takes months or even years to resolve, and often results in thousands of dollars in legal fees. So to avoid these kinds of issues, we suggest that the donor or the owner maintain a list with all the art that they own and the person or charity that they intend to give the piece to when they die. So on that list, you want to be really specific in regard to both the art and the beneficiary. We also generally advise that the donor or the owner talk to their heirs and see which, if any, of their items are important to the beneficiaries. And that conversation often gives some indication regarding the pieces that might cause future disagreements. Things like whether beneficiaries are even interested in the art, right? Might they prefer a more liquid gift? If certain pieces or collections might have more sentimental value to a certain beneficiary. Another thing we often do to keep things fair among beneficiaries is to provide for an equalizing gift to the beneficiaries that aren't receiving the property. One child receives a piece of art and the other children receive a monetary gift, generally equal to the fair market value of the piece. But before you decide whether an equalizing gift is appropriate, the donor should consider how the other beneficiaries will feel if they gift a piece of art to just one of the beneficiaries. For example, if one child is given a painting, how or if will they equalize the value with the other children? Will it be a monetary gift, or is there other pieces of art that the other beneficiaries might prefer? And another thing to consider might be how the recipient of the piece of art will feel if their inheritance is illiquid while their siblings receive more liquid inheritance. While equality it's not a mandated concept, this truly can help promote family harmony and avoid conflicts, among family members in the future. One other consideration when gifting art is whether an additional monetary gift to provide for the maintenance of the piece is appropriate. The donor will want to consider the recipient and whether they have the means to properly care for the piece. As you know, maintaining a piece's condition is crucial to maintaining its value. And maintenance of art can be really costly. It might include things like, appraisal fees, insurance agents, framing experts, just to name a few. And failing to take these costs into account might force a recipient to sell a piece rather than cherish it as the donor had hoped. Another tool that we use to promote fairness and harmony among beneficiaries is a right of first refusal, or an option to purchase art from the estate. A right of first refusal provision gives beneficiaries the right to purchase an asset or assets from the estate under the same terms and conditions as would be made by an independent third party. Generally, this is fair market value. And if the beneficiaries fail to exercise the right after a specified time period, the right terminates. And this arrangement allows beneficiaries to receive some reassurances that the assets will be sold at fair market value so that they get the full value of their share of the estate. Also, the beneficiaries are provided with a legitimate opportunity to purchase the assets and obtain ownership of assets that might have meaning beyond the monetary value. So, all that said, a right of first refusal can be a useful legal tool to ensure that certain types of property end up in the hands of those who value them most, while still balancing a family's desire to fairly distribute the assets. And lastly, it's important to designate who bears the burden of any taxes due. Is this the recipient, the estate? We've seen all sorts of different arrangements, but in any event, the testamentary of the planning documents should specify who will bear the burden of the tax that's attributable to each bequest. Thinking about all these things and incorporating these provisions in planning documents, as I mentioned, help promote family harmony. It will also help avoid conflicts among beneficiaries after the donor's death. And with that, I will kick it back to Ben.
Amanda. So far we've covered post-death sales and dispositions to family members, but what about considerations when making bequests to charities? There is one cluster of issues that I always like to think about, and that's acceptance, retention, and display. And when I think about these issues, I do have to think about them based on where a given collector might be on a certain spectrum. On one end of that spectrum are collectors who are happy to just give their art to a charity for immediate sale, so the proceeds can go towards that charity's operating expenses. For this kind of client, they're not worried about retention, they're not worried about whether or not the art will be displayed for public view. They're going to let the next owner think about that. For these types of clients, it can be as simple as identifying the piece of art and identifying the charity that they want to receive it and building that into their estate plan. If the goal, though, for this client is to get a certain amount of value to a charity, not just this piece of art, it might be worth keeping or having regular appraisals done to make sure that they're at least in that ballpark of what they want their charity to receive. Somewhere in the middle of the spectrum are collectors who want to give to an institution or a charity, and they have concerns of whether or not the art will be accepted. Will the art be retained, or will it be sold? Will the collection be broken up or kept together? And will it be out, and will the public be able to actually see the art going forward? So for instance, a collector of Edo period woodblock prints might want to give the collection to a favorite local modern art museum or to the alma mater, the museum at their alma mater. But if they want to be sure that this collection is retained and displayed by the donor institution, well, it's a nice gift, they might not be the right option to receive it. So for these types of clients, the things that I would want to have them be considering is, can the donor even accept the art? What are their acquisition policies? Does this art fit within the type of art that they're able to take on? Will the donor retain the art? Will they actually keep it in their collection, or will it be sold? Will the donor loan the art out to other institutions or make it part of traveling exhibits? Some collectors might want their art to be seen by as many art goers as possible. Others might want their works to only be seen in a very specific setting. Can the donor institution afford to care for the art and pay for the insurance? The budgets at the museum at a small liberal arts college can be very different than the Getty and what they can do. Can the donee properly preserve the art? Again, this can be much more important for antiquity collectors. Taking care of a 3,000-year-old Athenian vase requires deep expertise and technical know-how that not all institutions have, but some do. Another thing to consider is legacy and acknowledgement. This can be really important. Some collectors want to continue being associated with their collection after death and be acknowledged not just for their generosity, but also for their taste in art. So it's important to know what kind of recognition the museum might give in return. Is it, are they going to be in a publication? Are they going to get a placard? And these are things that can start to be worked out during life as well. It's a good idea to have conversations with these institutions to see where they might line up or where they might not be good fit. This might be uncomfortable for collectors to have those discussions, especially if they want to avoid creating expectations in a potential donee. But one way to avoid that is to have third parties who can represent the collector have those discussions for them, like their attorneys, their art dealers, fiduciaries, and do that on an anonymous basis on their behalf. And then on the far end of the spectrum are other collectors who are so passionate about their collections that they're willing to make their own foundations to manage their collections after death and make sure they're preserved in the way that they want. A really great example of this is a well-known collector, at least in the Minneapolis and Los Angeles area, Frederick Weissman. For those watching Minneapolis, you likely know him because of the art museum that's named after him. It's housed in the Frank Gehry building on the University of Minnesota's East Bank. Well, he is from Minnesota. Mr. Weissman made his money living on the West Coast, and he was an avid collector of modern art and assembled a museum quality collection that he displayed right in his home in Beverly Hills. But he was so passionate about his art that what he wanted to do after he died was to have a foundation that would preserve the art and keep it in place in his house exactly where it was, although he was living there, so that art goers could visit the home and enjoy the art as he enjoyed it, as well as make the art available for loan and traveling exhibitions. I had the opportunity to work there for a little bit when I was in law school, and it's really, truly an incredible place and an incredible experience. Art is on every surface and fills every space. There's Rothkos on the ceiling, Noguchi sculptures in the living room, there's Boteros in the front yard. There's even a BMW motorcycle in the garage that was custom painted by Keith Haring. My favorite piece probably for him though is he had a private jet. It's a Lockheed Jetstar, which is already a great looking aircraft. And he had it custom painted by Ed Ruscha in a dark blue and gold celestial motif. If you've never seen it, I do recommend Googling it after this webinar and checking that out. But anyway, so for clients on this end of the spectrum, the considerations are even more complicated and more difficult. How much would a foundation need to operate? What kind of space can accommodate the collection? For Mr. Weissman, it was his home. For other collectors, they might need to think about spaces that they can use or acquire to do so. What are the policies behind whether pieces should be loaned to other exhibits? What are the policies behind whether pieces can be sold, especially if the foundation needs more operating funds 10, 20, 30 years down the road? And then perhaps most importantly, is making sure you get the right team in place to help manage the art and the foundation as well. So a lot to think about with respect to the acceptance, retention, and display issues, especially based on where the client might be on any given spectrum and what their desires and financial resources are. For estate tax considerations, there is an unlimited charitable estate tax deduction for bequests to charities, but in order to receive that, the charity must actually be able to accept and receive the asset. So another reason to make sure that the acquisition policies of the donor institution would allow the art to be accepted by them. And Amanda, I will pass it back to you.
Thanks. So next, I'd like to just talk briefly about the responsibilities of a personal representative when administering an estate with art. So you've been appointed personal representative. Right now, what should you do? And Ben alluded to this earlier, but when administering an estate with valuable works of art, first and foremost, the PR should be sure to obtain insurance at the proper levels. And this means a policy that covers the interests of the estates and the beneficiaries. By way of an example, we look to transfer on death deeds. Transfer on death deeds, or TODs as they're often known, have become a really popular planning tool here in Minnesota and elsewhere. What TODs do is they convey property from one person to another. So they're recorded prior to the grantor's death, but they don't become effective until after the grantor's passing. So what this does is it allows the property to pass to the grantee outside of probate. However, in 2019, a Minnesota court heard the case Strope Robinson versus State Farm Fire and Casualty Company. And this case offers what I would call a cautionary tale. So a little background on the case. Mr. Strope executed and recorded a Todd that would transfer his home to his niece at his death. The home and its contents was insured by State Farm, and Mr. Strope was the only named insured under that policy. Mr. Strope died, effectively transferring the home to his niece, so the Todd worked as intended. However, a few months later, Mr. Strope's ex-wife burned the house to the ground. So shortly thereafter, the niece filed an insurance claim for the destruction of the home, but as you probably guessed, State Farm denied the claim. So the niece sued State Farm to recover the casualty insurance benefit. Unfortunately for the niece, though, the court held that because the niece wasn't a party to the insurance contract, and because Mr. Strope no longer owned the home and therefore did not have an insurable interest in the house at the time of the fire, essentially there was no named insured with an interest in the house and its contents, and therefore no casualty coverage was available. And I say all of this to highlight that the personal representative really should consult with an insurance agent about how to best protect the assets of the estate. And this is particularly true when a Todd is present. One other thing that the personal representative must do is to securely store the artwork. Excuse me. And this could mean a variety of things, from changing the locks to moving the art to a secondary location. Really anything that might be needed to protect the assets of the estate. For a perfect example of what a PR should do in regard to proper storage of estate assets, we look to the estate of Andy Warhol, where the court specifically applauded, in its opinion, the personal representative for securing Warhol's home. And they did this on the very day of his death and didn't lose a single object to theft or misplacement. This is noteworthy because the home contained over $100 million of valuable objects. And people were seeking entry to claim ownership of those objects from the day of Warhol's death forward. And I've actually seen this in a number of administrations. The personal representative doesn't secure the assets, and shortly after the death, family members take valuables. And then months later, the PR has to explain to the court why the estate inventory is missing certain assets. An estate that I'm currently working on has a several $100,000 insurance claim pending due to artwork that went missing between the date of death and when the personal representative was actually appointed. And this estate had so many assets that the only reason the family even noticed that the art had gone missing was due to the fact that an appraisal had been done a few months prior. On a related note, the personal representative is also responsible for marshaling the assets of the estate. And what this means is that the personal representative must locate and take charge of all the assets. For example, if works of art are on loan to a museum or other location, the PR should notify the borrower of the estate's intent to preserve its interest in the works, and if appropriate, demand return of the works. If the decedent didn't keep good records, this can often feel as if the PR is playing detective. Recently, the PR of an estate that we're administering found out that the decedent rented several storage units, one of which was filled almost to the point of not closing with pieces of art and other home goods and things. And at the time the PR found out about the units, they were less than 30 days from being auctioned to the public due to lack of payment. Lastly, the personal representative must determine the ownership of the assets. The PR should determine whether anyone besides the decedent owned an interest in the works, whether the works are owned by an individual, an LLC, partnership, entity, etc., and whether the decedent gave any fractional interest in the works to children, friends, museums. To help with this process, the personal representative should gather all of the appropriate provenance documents, appraisals, bills of sales, and any contracts that are in place regarding the art. All that said, the personal representative has a fiduciary duty to identify and protect all the assets of the estate. And taking these 4 steps will go a long way in fulfilling that duty. And lastly, we'd like to leave you with a few pointers for drafting testamentary documents that apply to an estate containing art. First, with regard to the financial power of attorney, you want to be sure that the document expressly authorizes the attorney, in fact, to deal with any copyright matters. And this would include things like negotiation, arrangements with dealers, etc. And this piece is particularly important if the testator is an artist. Second, the will or trust document should not dispose of valuable works of art using a standard tangible personal property provision. And this provision usually sounds something like an equal shares to each of my surviving children. And for the reasons we talked about earlier, a provision like this really is not helpful when you're dealing with items that can't easily be divided, like art. Instead, as I mentioned, the testator should use a tangible personal property list that clearly indicates each piece of art and its beneficiaries. In addition, if the art is to be sold and proceeds split among beneficiaries rather than the art itself, that should be explicitly stated in the document and give the PR or the trustee the power to do just that. Also, if the testator is considering giving heirs a right of first refusal or option to buy from the estate, or including an equalizing gift, these should also be explicitly stated in the planning documents, as well as a tax apportionment clause. Taking time to address these things on the front end during the planning process, rather than dealing with the issues that tend to arise from lack of inclusion in the planning documents, can save a significant amount of money in litigation fees, not to mention, saving the surviving family members from the type of discord that often happens when the beneficiaries feel as if they've been shorted in their inheritance. Well, that concludes the substantive portion of the presentation. We hope that you found this helpful and that we give you some things to consider when dealing with an estate that contains art, or when planning for how to dispose of art during death. We would be more than happy to talk with any of you in more depth, or about any of the topics that we really just managed to scratch the surface of this morning. Our emails are listed here. And it looks like we're just about out of time. So to be respectful of your time, we'll get wrapped up here. But if anyone has any questions, if you want to put them in the chat, we can respond via email after the presentation. Or if you want to email us directly, whatever works for you. So again, we just want to thank you all for coming, and we really appreciate you being here and hope that you enjoy the rest of your day.